All right, everybody, we're going to go ahead and get started. Welcome to Know Your Rights, Understanding Louisiana's Pregnancy Accommodations Law. I'm Amanda Brunson, Director of the Office on Women's Policy within the Governor's Office, and we're delighted that you are spending your lunch hour with us today. Before I jump into telling you more about our office and about the webinar today, just a little bit of housekeeping. This webinar is being recorded, and a little bit about the agenda. We're going to tell you right up front how this Act 393 came to be in Louisiana. You'll hear from one of our partners, the Louisiana Breastfeeding Coalition, and then we'll have the bulk of our webinar with Cameron Dawson from A Better Balance to talk to us about the ins and outs of the law, and then we will have time for Q&A. So you should have a Q&A box at the bottom of your screen, and feel free to type your questions in there and we will address them at the end. So about the Office on Women's Policy, it was created in statute many years ago, and we really are tasked with keeping a pulse on the top issues that impact women in Louisiana and their possible solutions. So we do a lot of research, but I can tell you the part of our jobs that we love the most is really being a conduit of information with all of the many partners that we have outside of state government, with the different branches of state government, with nonprofits, with universities, with our national partners like A Better Balance. This is really the lifeblood of the work that we do. And that ultimately is what led us to have this new Act 393 in Louisiana. So this work around Act 393 has been in the works for a couple of years now. We have a core set of partners who pulled it all together for 2020, but then Senator Barrow was not able to run the bill because of COVID that year. So we ran it again in 2021. Just a little bit about the group of people who worked behind the scenes on here. I'm sure I'm going to leave somebody out, but I want to give you a quick list so that you get a feel for how broad this coalition is. It was the Louisiana Budget Project, the Institute for Women and Ethnic Studies, the Amandla Group, the National Birth Equity Collaborative, March of Dimes, the Partnership for Children and Families, the Louisiana Department of Health, the Department of Children and Family Services, A Better Balance, the Breastfeeding Coalition, the Power Coalition, Agenda for Children, the Workplace Justice Project, and many advocates who, whether they were technically representing an organization or not, all came together to form this coalition to get pregnancy accommodations in Louisiana. So huge thanks to everybody there for their work. But I'll tell you that Louisiana really was a trailblazer when we got our first pregnancy accommodations law in 1997, which was really not about accommodations, honestly. It provided for a job transfer if there was a medical reason for a woman to need that in her pregnancy. And then it also protected against pregnancy discrimination, which obviously is the thing, it's important, but this was really needed because it goes beyond that. Many women want to work throughout their pregnancy, but they just want to do it safely. They don't want to have to choose between the health of their pregnancy and keeping their job. So this is really the fruit of all of that work, and we're excited to be able to share it with you today. It's really about maternal health, it's about birth outcomes, but it's also about economic stability for families. So we have, like I said, lots of partners in this work, but we have two in particular that are here with us today and are going to share with us more about the work that they do and really get into the nitty-gritty of Louisiana's new law. So we are going to start with the Louisiana Breastfeeding Coalition, and Marcy Brewer and Betsy, I should have asked how to pronounce your name. We've connected forever, but Marcy, tell me, or Betsy came off. Betsy, tell me.
No problem. It's Betsy Dancesack.
Dancesack.
Yeah, thanks, Amanda.
Betsy Dancesack and Marcy Brewer with the Louisiana Breastfeeding Coalition. So I think Marcy's going to take the lead here, but I want to introduce you all. So Marcy Brewer is the Neonatal Initiatives Manager for the Louisiana Department of Health, Office of Public Health, Bureau of Family Health. As the Neonatal Initiatives Manager, Marcy leads the Bureau's breastfeeding strategies and the Louisiana Perinatal Quality Collaborative, breastfeeding and perinatal neonatal substance use quality initiatives. In 2008, she was awarded a Master of Public Health with a focus in maternal and child health from Tulane University. Her passion for breastfeeding and maternal and child health developed when she worked in Western Samoa in their Ministry of Health and with the WIC program in Fairfax County, Virginia. So please help me welcome Marcy Brewer.
All right, can you hear me okay?
Yes.
Okay, good. Awesome. Okay. Thanks, Amanda. Amanda, for that introduction, and thanks to everybody who made this act come to fruition. It's always been a dream to see that come through for birthing and parenting and breastfeeding persons in Louisiana. So I'm just so thrilled that it finally happened. So you can go to the next slide, please. Or can I? Okay, perfect. Thanks. So I wanted to spend just a few minutes highlighting 3 specific strategies and initiatives: the Louisiana Breastfeeding Coalition website, the Louisiana Workplace Breastfeeding Support Program, and the Well Ahead Initiative, and our statewide lactation accommodations work group. You can go to the next slide. So we'll post the link to the Louisiana Breastfeeding Coalition. Awesome, already done. Thank you. In the chat, so you can head there. You can actually go to the next slide. The Louisiana Breastfeeding Coalition website is really, I think, a good one-stop shop for just general breastfeeding information, and then some project-specific stuff. For instance, it's also, I think, a very easy website to navigate as well. So when you go to the coalition website, you'll go to projects and you'll go to workplace. There you will find this landing page, and on this landing page you'll see information about why it's important to support nursing mothers in the workplace. And then it also provides some quick links to the workplace breastfeeding support program that I'll talk about in a minute. It lists all our breastfeeding friendly designated employers throughout the state, and then also provides some additional information about time and space, and also like example policies and things like that. Next slide, please. If you go over to the advocacy tab, you'll come to this landing page, and at the bottom, there's these 3 squares. If you click on the Louisiana law link, you'll be taken to a page that provides links to all of the breastfeeding and pregnancy-related laws, I think all of them, on that web page. So Act 393 is there, and then the other breastfeeding-related laws as well. You can go to the next slide. And if you go to the resources tab, you will also see lots of topics in which we've listed a lot of resources, and then there's a drop-down menu for employment. And there we've highlighted a lot of awesome resources, some from A Better Balance, some from the United States Breastfeeding Committee, resources for both employees and employers. And I should have prefaced talking about the website with this, but we are, after this webinar, going to be making updates to include more language and information about other pregnancy-related accommodations, not just lactation, and provide even more information about Act 393 as well. And so if you visit the website and you have some suggestions about resources we should include, or information or language, please let us know, and we'll make sure it gets updated. Next slide. The next thing I wanted to highlight is the Louisiana Workplace Breastfeeding Support Program. This initiative is a collaboration between the Coalition and the Office of Public Health, Bureau of Family Health, and the Bureau of Chronic Disease and Healthcare Access, also known as Well Ahead. The landing page for this program, again, also on the Louisiana Breastfeeding Coalition website. And what this program seeks to do is to inform employers about the federal and state pregnancy-related accommodations, and also provide technical assistance to employers and employees as well. And then we also provide a designation. We work in close partnership with the Well Ahead Initiative, which was established in 2014. And so they have regional reps that are out there working with healthcare facilities, faith-based organizations, child care facilities, schools, universities, other work sites, to help them create environments that help reduce the burden of chronic disease, and create policies and procedures that help create healthy environments in these establishments and workplaces. And lastly, so just to go back really quick to Well Ahead, what Well Ahead has done is actually They have designation well spots. They designate all these establishments and employers as well spots. And what they have done is include the workplace breastfeeding program designation criteria, as well as other breastfeeding related designations we have, into their well spot benchmark. So actually most of our referrals come from well ahead. So it's really, truly a great partnership. Next slide. Thank you. So the last thing I wanted to talk about is the lactation, statewide lactation accommodations work group. So this is a group we established in 2018 that encompasses community, state, and local leaders and employer influencers that help us identify outreach opportunities, help us establish partnerships, and help us identify other levers and opportunities to influence workplace culture statewide and really improve support for birthing persons or birthing employees who choose to breastfeed. We also convened this group to help us ensure that we were inclusive of employer and employee perspectives when we're planning and implementing this initiative, the workplace breastfeeding program. And in addition, this group has been really key in helping to support dissemination and spread of successes and best practices. I think I have one more slide. Awesome. So one thing I wanted to mention before I toss it over to Cameron is that, you know, the three things I talked about, I think have kind of been narrowly focused on the lactation part of all of this. But one thing that we're really hoping to do and starting to lay the groundwork for is to really expand to cover the spectrum of pregnancy-related accommodations and family-friendly policy that's needed. So if anybody's interested in joining the statewide lactation accommodations work group or getting engaged in any of the other things I mentioned, feel free to just email Betsy or myself. Thanks.
Thank you, Marcy. And we'll leave that contact information up there, and we can also probably copy and paste and put it in the chat. If T hasn't done that already, we can do that in just a minute. Okay, thank you for that. And the Breastfeeding Coalition, that's exciting stuff. It's exciting to know that there's a whole network of employers out there and people who are working together from both the employee and employer perspective to make sure that we have good family-friendly policies in place. And I hope that that method expands to not only include the rest of this work around Act 393, but also many more things that we could be doing together to help create better work-life balance for families. So I'm thrilled next to introduce Cameron Dawson. Cameron worked tirelessly with us to get Act 393 passed in Louisiana and is really an expert in this work who is consulting with other states too. And so we're so grateful for her time that she has spent with us and the time that she gives us today too. Cameron Dawson is a staff attorney at A Better Balance, where she works on state legislation, litigation, and public education to advance justice for working families in the South on issues ranging from pregnancy accommodations to paid family leave and other policies. She believes that by using the power of the law to advance workers' rights in the South, we will not only make our nation healthier and stronger, but also tear down the systemic barriers created by racism and sexism. So please help me welcome Cameron Dawson.
Thank you so much, Amanda. And I cannot say that any of this work would be possible without the partnership and support of many of the organizations who were influential in passing Act 393, such as the Governor's Office, the Louisiana Budget Project, and Louisiana Institute for Children and Families. And so I just want to say this webinar is really just an overview of what is in Act 393, and it's for informational purposes and does not constitute legal advice. But if you do have any questions on what Act 393 does or are interested in seeing resources, I'll share that at the end of this presentation, as well as feel free to contact me at my email address, which we'll also share in the chat. So I just wanted to share some of the new provisions that Act 393 brings to the amended law that was passed in the 1990s. But I also want to say that this law does not take away from the maternity leave provisions that were already provided, such as 6 weeks for normal pregnancy or up to 3 months for those who are experiencing pregnancies that have a disability. And it also doesn't dilute any of the protections for pregnancy discrimination, but it just enhances some of those protections for pregnant workers. So if you'll just go to the next slide, I'll just share a little bit more about what a better balance does. So as Amanda said earlier, we are a legal advocacy organization, which means that we try to use the power of the law to advance justice for workers so that they could care for themselves and their loved ones without risking their economic security. And I work primarily in our Southern office, which is stationed in Nashville, Tennessee. And we do work across the South, leading issues that support pregnancy accommodations in the workplace, lactation accommodations, and protection from discrimination, as well as paid family and medical leave and paid sick time. And we try to work with partners who are connected and on the ground on these issues and give that legal support, whether that be through contacting stakeholders or, like Amanda said, working tirelessly to push these issues in the legislature. And so we are happy to support and lead on those issues here in Louisiana. And next slide. And so just to give a little bit of a background, so before Act 393, Louisiana law only provided pregnant workers with the right to request a temporary transfer, whether that be to a less strenuous or hazardous position if they had medical needs related to their pregnancy. And oftentimes they would need to provide a doctor's note. And so federal or state law did not explicitly provide for reasonable accommodation. So if a worker needed a water bottle or an additional bathroom break outside of a transfer, the federal or state law that protects against pregnancy discrimination did not guarantee that right for workers. And so we often saw that sometimes workers would be pushed to unpaid leave if they were not given that other accommodation, or they may have been pushed off the job entirely and forced to quit because they would not have that clear guidance from the law to give them that guarantee that they were allowed that accommodation request. So we really do think that with Act 393, not just pregnant workers, but workers who are recovering from childbirth, workers who are either chest feeding or breastfeeding and need additional accommodations will be covered under Act 393 when they do need accommodations to stay healthy in the workplace. And so the Louisiana Pregnancy Accommodations Law was sponsored by Senator Barrow and passed with tremendous bipartisan support in both chambers of the House. And as we saw, constantly when talking to legislators, this law benefits employees, it benefits families, and also businesses. This is a measure that improves maternal and infant health outcomes by allowing mothers to continue to work safely in the workplace, to take care of their health needs, whether that be, additional rest breaks or meal breaks so that they can have a snack to control their blood sugar and make sure they're healthy. But it also limits the chances of preterm birth outcomes because there's less stress on the mother while she is working. And then we also were able to see that time and time again, measures like pregnancy accommodations and accommodations for postpartum workers increase the number of working women in the state and keep women connected to the workforce. As we've seen, especially during the pandemic, there's sort of been a she-cession of women leaving the workforce, whether it be for childcare needs or because they're pregnant and unsure of what their rights are when requesting accommodations. But Act 393 really does give that clear guidance of what employers can do to really support their employees in the workplace. And not just benefiting employees, but this bill does in fact reduce healthcare costs for employers, whether that be through insurance or added costs of care when workers are facing those detrimental health outcomes. And it does provide clear guidance. So employers know that what their responsibilities are in having these conversations with their employees, where do the guidelines fall and what types of accommodations can be done or what examples can be started. and then also reaching informal resolutions without litigation. So that way employees stay safe on the job, but employers know what their responsibilities are. So this is just a little background on Act 393. And I wanted to get a little bit more into the weeds of what this law actually does. And it protects pregnant employees and those who have recently given birth from discrimination in the workplace by requiring employers to provide reasonable accommodations to employees with known limitations related to pregnancy, childbirth, or a related medical condition. And it's actually written in the act that related medical condition specifically includes lactation, as well as other examples of pregnancy-related needs. But a pregnant or postpartum worker who is still continuing to chest feed or breastfeed can use this act to continue to breastfeed up to a year. And they can use the examples from the reasonable accommodations law in order to stay healthy and continue that practice so they could keep their milk supply up. Because as Marcy and others have shown, there are added benefits for breastfeeding and chest feeding to both mothers and babies. And so our ultimate goal is to make sure that there are positive outcomes for mothers and families in Louisiana. And so on the next slide, you'll see just some examples. Now, I want to say too that this is not intended to be an exhaustive list. This is just some of the examples that employers can provide or employees can ask their employer to provide. But the law does also say that your employer can provide other reasonable accommodations as long as they relate to your medical needs. And so these are just a few examples. Your employer, you can request your employer to make existing facilities readily accessible and usable, whether that be repositioning your station to closer to a bathroom or providing you with a chair or a stepping stool so that you can use facilities that are essential to your job. You can also request that you have a modified food or drink policy. So whether you need a water bottle at your station or additional breaks to eat snacks, that way you can continue to make sure your iron levels are high or your blood sugar is at a normal rate in order to stay healthy on the job. And then we also have acquiring or modifying equipment, devices, or your workstation so that you can continue to work safely. And this includes a uniform change. If you are, working in a retailer and you need a uniform modification so that it's not putting pressure on your belly or your back. If you need additional devices to help you do your job, you can also request that. As it relates to your medical needs. And this covers pregnancy, childbirth, or pregnancy-related medical conditions. And then it does still keep that temporary transfer language from the prior Louisiana law, because that is an example of a reasonable accommodation for some workers. So we wanted to make sure that if you are qualified for that transfer to a vacant position or a less strenuous position, you can also ask for that as a form of a reasonable accommodation. And the next slide is just going to show a few more examples, and feel free to put any questions you have in the chat. And I'm happy to take those questions too. And so again, this is not an exhaustive list, but this is just some examples of accommodations that we have heard from our free and confidential legal helpline, as well as working with other partners in Louisiana from what they've heard workers really need. And so also a worker could ask for a modified work schedule, whether they need to be on a reduced schedule or part-time because of childbirth-related needs or pregnancy-related needs. If they need frequent or longer breaks, they can also request this as an example, but and some of these breaks can be compensated if their employer is already providing compensated breaks. But oftentimes we see that they may be given an additional 15-minute break that may be unpaid, but if there's a policy in the handbook that provides for compensated breaks, that could also be paid as well. And just wanted to add too that this law does provide for accommodations for mothers who are nursing or lactating in the space for up to 1 year after their child's birth, which follows the federal law. And so they can be given a private non-bathroom space to express breast milk. If they are not covered under FLISA or the Affordable Cares Act, then the pregnancy accommodations law can also extend protection to some of those workers, whether they be a nurse or an administrative worker who is exempt from those FLISA laws. So these acts are really important in ensuring that more workers are covered and able to, ask for accommodations informally with this law and with proper protection from retaliation. And I also just want to say that this law does not just cover employees who are currently working, but it also covers applicants. So if you find that during the process you need accommodations or you mention accommodations to your employer, this law does provide protection against discrimination and also for trying to request accommodations while you are a current employee. So from day one, you are covered. And it does still cover employees who work at a job with more than 25 employees. So it extends coverage beyond federal law protections like FLISA for nursing mothers, but it also is the same as the state law in that employee threshold. So we just want to make sure that workers from all industries understand that if they work at a business with more than 25 employees, they do have the right to request accommodations in the workplace related to pregnancy or childbirth or their nursing needs, and that this law does give clear guidance and examples on what they can ask for, and at least gives them that confidence to continue to have that conversation. And I want to talk a little bit about the interactive process that this law does provide for. So typically, under other federal laws like the ADA, your employer has to work with you in order to find an accommodation for your disability or for a substantial medical condition that does affect your day-to-day activities. And so, like the ADA, this pregnancy accommodations law has similar language with this interactive process. And this means that an employer should work with you to find the right accommodation to keep you safe, healthy, and on the job. Now, this doesn't necessarily mean that there is a specific language or a right word, keyword to say, but we do have resources on how to talk to, how workers can talk to their boss about either their pregnancy or their lactation needs at these resources here. And it goes through the state law as well as the federal law protections, just in case some workers are not sure of what law to use when they're advocating for themselves. And we're happy to share that as well when we share the slides after the presentation too. And so as long as a worker who is covered under this law, meaning they work at a business with more than 25 employees and they have known limitations related to their pregnancy or childbirth or pregnancy-related needs, as long as they can request this accommodation, whether that be from the list of examples or another accommodation that they're needing to keep healthy, their employer has to provide that accommodation as long as it would not impose an undue hardship on their business. And this undue hardship is the same standard as the Americans with Disabilities Act. So that means it would have to be very difficult or expensive for the employer to provide. And so employers are used to this federal standard. They know which factors they have to look at. Sometimes it's the size of the business, it's the area where the worker is, as well as the resources that the employer has and the cost of these accommodations. But many times we found that these accommodations have, very zero to, if any, cost, especially when, it is something that is temporary and can keep that worker on the job and providing for their families during this crucial time. So there are some other requirements here that the law does provide for that do protect employers. So here, unless your employer does so for other employees or a group of employees who need a reasonable accommodation, there may be a group of employees who are injured on the job or a group of employees who have a disability, they are not necessarily required to create a new position for a pregnant worker or create additional employment opportunities for that pregnant worker. And also, employers do not necessarily have to discharge an existing employee or transfer someone who has more seniority to move that person out of the job and put the pregnant worker into that job position in order to accommodate them. Now, if they are doing this for other workers who are injured on the job, then this requirement does not apply. So they will have to, create an additional position if they're already creating positions for other workers who need accommodations. And this is just one provision that was added to make sure that employers knew their responsibilities. And also, for smaller businesses, they may be able to find an informal resolution instead of creating new positions. And as many our partners have heard from workers, that most of the time workers do need, slight accommodations, minor accommodations like a water bottle or an additional break, not necessarily a new position that is created. Okay, and so in terms of enforcement and protection against discrimination or requesting accommodations, we also thought that it was important for this law to be effective, to give confidence to workers so that they may use their rights and that they be protected from retaliation. And so we took this language and also made sure it was incorporated into Act 393. And so when an employee is requesting an accommodation, it has to be an accommodation that the worker needs, that relates to their known limitations. And so an employer cannot force an employee to take leave if there is another accommodation that can be provided. And we've also found that many times in other states, employers will force a worker to accept an accommodation. And that really is not what the employee wants or needs. Sometimes employees do not necessarily need an accommodation at that time, but it may be a perception from the employer that because they are pregnant or they are just recovering from childbirth, they need an accommodation. This should be up to the employee and their decision. So we thought it was important that the law also protects employees from being forced to accept an accommodation. And also, it's important to protect employees from accepting accommodations that may not be necessary to perform the essential duties of the job. And so sometimes that does put a little extra stress on the employee to do that when they can necessarily perform the job without the accommodation. And like I said, this law does protect against punishment or retaliation for requesting an accommodation or trying to use this law in advocating for themselves. And also it protects against denying future employment opportunities or promotions if for applicants or existing employees, if they do need an accommodation and they're being penalized for using this law. They should be allowed to receive promotions or other employment opportunities just so that they can continue to be safe and work and protect themselves and their baby. So this is just a little bit of an overview on employees' rights. And I did want to kind of highlight some commonly asked questions that we have seen. And like I said, I'm definitely gonna, Amanda's going to be able to share some of the questions as you put them in the chat as well. So definitely keep those coming. So one commonly asked question we hear is, do you as a worker or one of your patients have to be disabled in order to get an accommodation under this law? And no, the answer is no. So unlike the Americans with Disabilities Act, which covers some pregnancies that may be high risk or may have severe conditions like gestational diabetes or preeclampsia, this law, Act 393, does not require a pregnant worker to have a disability in order to get an accommodation. So an employee can have a healthy pregnancy and simply need a job adjustment because they have a known limitation related to their pregnancy. It could also cover workers who have recently returned from childbirth who may need additional leave or additional accommodations to care for their health needs. So you don't necessarily need to have a severe disability in order to request accommodations now that this law is in place. This law, we also hear questions of if this law does protect against breastfeeding and also protects against discrimination for lactation needs. And the answer here is yes. So under the law, employers are required to provide a private non-bathroom space for expressing breast milk And it also does allow for workers to request other accommodations for breastfeeding needs, such as frequent breaks to pump, and also, an additional modification to job duties or job equipment, just in case they do need that additional accommodation. So it does cover, these are the same accommodations that are covered by federal law under the FLISA and Affordable Cares Act, but we found that many workers are actually exempt from federal law, whether they be an administrative worker or a nurse or a teacher. There are some exemptions that this law does cover, and it fills some of those gaps. And so for workers who may have experienced the need for accommodations or pregnancy discrimination on the job before this law went into effect on August 1st of this year, how do they see if they have any legal protections or what they can do, what their options may be? And that really does depend on that specific situation, which is a clear, legal answer. But I think there are some different laws that may offer protection for them if they had pregnancy-related needs before August 1st, and they may have seen that their hours were cut, or they may have been terminated for their need for accommodations. So I really do encourage you to share these resources with folks. And if they have questions, they can give us a call at our free and confidential legal helpline. And that way we could see what their legal options may be in that case. Now, this law did go into effect on August 1st, 2021. So from the beginning of August to now, workers have a clear right to pregnancy accommodations in the workplace if they are covered and work for businesses that have more than 25 employees. Now, this law, one thing we do here is if spouses or partners can take time off for their wife's pregnancy under the law. And unfortunately, no, this law does only cover accommodations needed that are for one's own limitations related to pregnancy, childbirth, or a related condition that includes lactation. And so the maternity leave provisions that are in this law, they do only pertain to workers who have pregnancy-related needs or who are pregnant and going through childbirth. But we just want to make sure that workers know if they are pregnant or about to give birth that they have the right to these accommodations, even if their partners may not. Okay, and one last thing that I hadn't mentioned before was the need for a doctor's note. So before, Amanda had said that there was a law in the 90s that had given a right to request a transfer to a less strenuous or hazardous position. And that law did require a doctor's note in order to request the transfer. Now, one great thing about Act 393 is that this law does not require for a doctor's note to be given at that initial request. And this was really, part of an equity piece, and really important for workers to know that they do not have to go through that extra barrier to request accommodations, especially ones that are temporary and quick and can really keep them safe. But there are some cases where your boss may ask for a doctor's note in order to confirm that medical need. And I would just say, if that is the case, especially if your employer asks other workers for a doctor's note that may have light duty needs or maybe disabled, just make sure that the doctor's note is as specific as possible and outlines what you can and cannot do at work. Because oftentimes, words like light duty or notes that do not list what the condition is may be too vague, which means that it could take longer to really process that accommodation request, and it may signal to your employer that you're no longer able to do your job. And so what you really want to do is have a specific doctor's note that, if you have to provide one, that gives an outline of what your accommodation request is, how long you may need it, and why you necessarily need that accommodation. So just wanted to add that last bit of information in. And some of the resources, which we will link to in the chat, are just the states' rights, worker rights hub. So we have on A Better Balance a web page that goes state by state on what your rights are whether you're caring for yourself, you're caring for a loved one, you're currently pregnant and have questions about your needs, or you need information on your rights to paid or unpaid time off for maternity leave, or your rights for nursing in the workplace. And so this is our website for that Know Your Rights page, and it does have information specifically for Louisiana. And we also have additional resources at our helpline, which is free and confidential for workers. So oftentimes we see that workers are not sure if they need an attorney, they just have questions, and they're not able to pay for a high consultation fee. So they can contact our helpline number, which is 1-833-633-3222 or 1-833-NEED-ABB. And they can also fill out a form online at abetterbalance.org/gethelp. And this way they're talking with an attorney for free. They're able to ask any question they'd like, and we do follow up with them to make sure that they can, really enforce these laws. And if not, we can, see their legal options for enforcing these laws. And lastly, I'll just say, I know this is a lot of information, especially in an hour, and we really do appreciate you taking this time out of your day. So we have this information on an updated fact sheet. It goes over who is covered, what can be asked, what requirements are in the laws. And it really is sort of a simple format, either to hand out to your networks or the workers who you're working with and hearing from. And feel free to share that information so that they can, sometimes they're handing the information to their employer, or they're sharing the information with other workers, and they're really being leaders and pillars in their community. So we just wanted to kind of make the information as easy as possible to share. And so sorry for talking too long, but hopefully this information was helpful. And I'll definitely turn it over to Amanda.
Thank you, Cameron. It wasn't too long. It's a lot of information, but I feel like you broke it down for us in some really easily digestible nuggets. So we appreciate that. So we do have a couple of questions in the chat. The first is Dr. Preston is a coroner in Louisiana, and he says, I've reviewed Act 393. I have an investigative division of the coroner's office and employ women of childbearing age. Heavy lifting is a core duty, and there's really no light duty or alternate job for them. Am I correct that according to Act 393, I do not have to create a job to accommodate the pregnant or postnatal employee if they cannot perform a critical function of their job?
Thanks, Preston, for that. Charles, for that question. So I think with Act 393, there is a provision that does say, unless, there is a creation of new jobs for other employees who have that need for an accommodation, or for other employees who may need light duty, an employer is not required to create a new position or additional employment opportunities. But I would say there that is a time to be creative about what that accommodation could look like in order to address that employee's specific needs. So sometimes that may look like manual assistance from another employee temporarily for a set period of time, or that may look like, giving them additional equipment so that they can do the heavy lifting, whether that be a cart or, an additional chair or another position. So I'd really urge employers to be creative in working on a solid solution for employees. That way, when there does come a time to see if it would be an undue hardship for the business, or if unpaid leave would be the last resort, you can say that you've gone through the course and the interactive process successfully. And like others have pointed out in the chat, right, the undue hardship. So that too difficult or too expensive standard would come in, but the last resort would be unpaid job protected leave, if that makes sense.
Yeah, thank you for that. I think that was what helped me wrap my head around this as we went through this process, is that, the whole point of this law is to open up a conversation between the employee and the employer about what's needed, and then to work together to find a solution. And so it may be that some businesses can accommodate a job transfer temporarily, or assistance with heavy lifting, through other employees who are willing and volunteering to say, hey, I don't mind helping out with this temporarily, to, a whole range of things that ultimately can end up with unpaid leave. But that's what we're trying to prevent, is making sure that we can keep people connected to workforce, especially at a time that we know their expenses are, as a family, are growing whenever you're adding to your family. So, and then Dr. Raby put into the chat, Dr. Raby's with the director of the Louisiana Commission on Human Rights, and that is the place that you go, I guess, if you have a complaint about employment discrimination in Louisiana. And she reminds us that you would treat them as you treat any other individual with a disability. However, you would have to prove the undue hardship, try to be accommodating. And I think that also was a piece that really, you opened my eyes, Cameron, and how this works. So through the Pregnancy Discrimination Act, employers have to treat their pregnant workers the same way they would treat any other worker. So if they're already making accommodations for other workers who, like you said, were injured on the job or who have disability related needs, if they're creating light duty positions for other people, then they would have to create a light duty position for the pregnant worker. And that was already the case under the existing pregnancy discrimination law. So this is just saying that regardless of what you're doing for other people, if you have a pregnant worker, then you need to start the process about reasonable accommodations if there's a medical need related to pregnancy, childbirth, or other related medical conditions. So the next question is, are there any state or federal dollars to offset the cost of these mandates?
And yeah, I would say this isn't necessarily a mandate. It's more of providing clear guidance on what the responsibilities and rights of employees are, and the responsibilities of employers. And I think before there was some confusion on what accommodations could a pregnant worker request. Did they have to wait till they rose to the level of a disability, or did they have to, see what other workers were receiving in order to ask for an accommodation? So this law does provide that clear guidance to say, like Amanda said, it doesn't matter how other employees are being treated. If you have a pregnancy related need or a need related to childbirth or lactation, you can simply, go to your employer, start this conversation and see what options can keep you working. But many of these accommodations are low cost to no cost, especially, if there's already a stool, if there's access to water, there can be, a minimal cost there.
Thank you, Cameron. And there's another question in the chat. It says, asking for clarification on whether employers with less than 25 employees must provide some accommodations.
Right. So, and this law, the state law, is more of a floor. So employers can always rise above the laws and do more. We do encourage employers that have less than 25 employees to continue to see in their policies how they can keep women attached to the workforce and keep accommodating pregnant workers. And so this law does only cover businesses with more than 25 employees. And so we've seen, though, that the Pregnancy Discrimination Act and the Americans with Disabilities Act, which are federal laws, they do apply to businesses with 20 or more employees. And there is Louisiana state law that does also protect workers with disabilities. So there are a few considerations under federal law to keep in mind for, but if you, we've heard, from other businesses that have smaller numbers of employees that they are already, trying to provide accommodations for pregnant workers. And we do urge them, to implement those policies to protect all workers.
Yes, and I don't know where it stands today, but there has been movement at the federal level on a federal Pregnant Workers Fairness Act, which the last time I had looked at it, it would apply to a lower threshold of employees, right? I think it was 15 or more at the federal law. So there's the potential that will come down and will help, cover that gap for some employees. Also, going back to the cost, if there were dollars available to help with the cost, I know, Cameron, you mentioned that many of the accommodations are low or no cost. I think that's the case for the whole huge body of research that there is out there about disability related accommodations, that most of them are either low or no cost. And so I think that's really huge and important to remember. And then in my conversations with several HR directors as we were working to get this law passed, we talked about the need for a doctor's note, and many of them said they're used to accommodating employees who request accommodations related to their disabilities, and that they don't ask for doctor's notes then either, unless it's something that is going to require significant costs, like maybe buying a new desk or something like that. They may ask for a note, but that by and large, HR departments are really like, a lot of these things are really simple and easy for us to accommodate. And so we don't even ask for a doctor's note because it's not costing us much or causing us a lot of anxiety or, shifting around to accommodate.
Yeah, and
Amanda,
I just wanted to, oh, sorry, go ahead, Marcy.
No, sorry. You go first.
I was just going to say, I think I misspoke a little bit. So with the state Louisiana law that covers workers with disabilities, that law is 20 or more, but the Federal Pregnancy Discrimination Act and the Americans with Disabilities Act covers employers with 15 or more workers. And so the federal law would, the new federal law, there's movement for a federal Pregnant Workers Fairness Act that would, follow that federal law process of covering workers with who work in businesses with 15 or more employees. But, many times we've seen states have been the leaders in this movement. And so we really do appreciate our state partners and, protecting workers while the federal laws are being pushed.
And I just wanted to piggyback on what Amanda said and just add that while there might not be, specific funding allocated to carry out, some of these accommodations, there is, good data about return on investment with accommodations, especially lactation accommodations. And I also think that, I know we're sort of in a COVID has led us to sort of a workforce crisis at the moment. And I think that employers that can, provide, accommodations and help folks, really balance work and family, I think we'll be able to hopefully make their work site more marketable and hold on to employees right now. At least that's my theory. I think it can help, not hurt.
That's a great point, Marcy. And a great note, I think, to end on. I don't see any additional questions. Cameron or Marcy, do you have any last thoughts that you want to share?
Not for me.
Yeah, I just want to say, even if you have questions about how to get the information out or any of the resources or what other states have done, feel free to contact the Southern office or the helpline or website. And, all of us here are definitely an added resource as well.
Thank you. Thank you for that, Cameron. Huge thanks to Cameron, to Marcy and Betsy and all of our partners for their work, not only to get this passed, but also to pull together this webinar and get this information out to everybody. But then huge thanks to all of you who are participants in the webinar, because this is the next step, right? It is informing everybody, engaging people, passing this on to your networks. We did record it, so we will share a recording with you. I think we may be able to share the slides as well. I'll follow up on that, but where you can then pass this on. So we're going to host it on our website. I think the Breastfeeding Coalition will probably try to put it on theirs, a better balance on theirs. So if you're a partner and this makes sense for your line of work, then please consider posting the link to the recording on your site as well. But really, this is the beginning. This is our opportunity to get the word out about what's available to workers in the state of Louisiana. We also want to point out that we, as the Office on Women's Policy, have a blast email list. We do not abuse that privilege. We don't send very many emails, maybe one a month, lately not even that often. So I encourage you to please send us an email and sign up if you're not already receiving those. We'll also share the recording there, but then we have other events like this, other events that maybe the Women's Policy and Research Commission or A Better Balance or some of our other partners are hosting. We'll put notice through that email list, so please sign up. So once again, thank you everybody for connecting with us, and I hope you all have a great day. Bye-bye.